Welcome to our 5th annual Licensing Liaison meeting. I'd like to begin by acknowledging the traditional owners' ongoing connection to and custodianship of the lands on which we meet today, and pay my respects to elders past and present. My name's Deanna Steike and I'm the Acting Executive Director for Assessment and Intelligence at ASIC, with executive responsibility for 3 teams, which includes licensing. This is our first licensing liaison meeting by way of webinar, and thank you very much for joining us. We've had over 300 registrants, so clearly there's considerable interest in licensing related issues. It's been a big year for all of us with COVID-19 and the additional licensing regulatory reforms implemented and coming next year and beyond. We've also just recently released our licensing report, which hopefully many of you have already read, and if not, then you can certainly find that on our website. I'll start by talking briefly about our approach to licence assessments, and then I'm going to hand over to Warren Day, who many of you know, and who was appointed to the position of ASIC Chief Operating Officer in August. And Warren is going to discuss some operational IT issues impacting licensing over the next few years. Peng Li is our Senior Executive Leader in Licensing, who will then talk about our past year's licensing performance. Nicholas Von Arx and Gerard Mithen are 2 senior managers in our licensing team, and they'll then discuss the recent and up-and-coming regulatory reforms. During our presentations, I'd really encourage you to submit questions to us. We have allowed some time at the end of the presentation to address your questions in a Q&A session, and we're going to facilitate that today via email. So the email address is going to flick up on the screen now, and it's ASIC Licensing Liaison at asic.gov.au. And if I could ask that you indicate your name and firm in the email, and please feel free to email questions through as they arise during our presentation. As you all know, the ASIC licensing function does perform an important gatekeeping role in both the financial services and credit sector, and we do apply a risk-based approach to assessment to ensure that only suitable persons and organisations are licensed and registered. The time that it takes us to assess an application is generally dependent on the quality and completeness of the information provided to us. So as service providers and applicants, you can really assist the time it takes us by ensuring that your answers are complete and that all the core and non-core proofs contain all the necessary information and no more. On the 1st of April this year, as many of you already know, licensing made its most significant updates to our regulatory guidance in several years. These include to our regulatory guides 1 to 3, so that's RG 1 to 3, which is the AFS licensing kit. We also made changes to regulatory guide 204 in relation to applying for and varying a credit licence, and RG 206 in relation to credit licensing competence and training. We also made minor updates to other regulatory guides on issues such as general compliance and organisational competence. Often, many of the questions we receive from applicants can actually be resolved by reference to the regulatory guidance, so I'd really encourage you and all prospective applicants and the service providers to review those documents before lodging your applications. Earlier this year in April, we also released 2 new information sheets outlining some additional information that we require from certain AFS or credit licence applicants. So you may be familiar with Info Sheet 240 in relation to AFS licence applications, which is around providing information for fit and proper people and certain authorisations. And we also released Info Sheet 244, again in relation to credit licence applications for providing information for fit and proper people. There's a key change that we will be making to our info sheets in the near future, but it will be applied to any current and future applications and relates to the evidence we will require for officers of ultimate controllers of an applicant. And this is squarely in response to feedback that we've received from many of you. And Nick will discuss these in more detail later today. The COVID-19 pandemic has had an impact on licensees and professional registrants in 2020, and we understand that this is likely to extend into 2021, particularly for our overseas located licensees. Now, we are aware of the difficulties that this may have on some applicants, and we have adopted a flexible approach to ensure that applicants are not fairly disadvantaged in the circumstances. And this includes logistical difficulties, including obtaining documentary evidence and being required to commence within 6 months of grant of the licence. We've also requested applicants to clarify the impact of the COVID-19 pandemic on their operations. And the responses indicate that many applicants have made changes to how they operate. Thank you, and I'll now hand over to Warren Day, Chief Operating Officer, to continue this morning's discussion. Thanks, Warren.
Thanks, Diana, and I can't see you all, but hello to everyone around the country who's joined us today. Thank you for that. I think I'd start by identifying and congratulating Diana for looking after assessment and intelligence. As Diana said, I've been granted the honour and burden to a certain extent of becoming ASIC's Chief Operating Officer. That's a mean feat during a pandemic while we're all working remote, which generally we still are in our Melbourne site, Melbourne teams. In fact, it's been 100 days since I commenced as Chief Operating Officer, and if you've been following all things ASIC, you'll know it's been an interesting and challenging time at the Commission over that period. I won't go into the details of that, but COVID aside, there are challenges in the issues in relation to James Shipton's standing aside and Karen Chester being acting chair at this time. But the thing to note and that I emphasise is that what hasn't changed is the commitment of ASIC teams and our people to continue the good work that ASIC does, and that's never been in doubt, and it's continued to be the case with our licensing team. So thank you all for joining us today to hear about the work of the licensing group. I would take this opportunity also to look back and say when responsibility for ASIC's licensing work came to what is our assessment and intelligence group, Peng Li and I were very keen to ensure that we were much more transparent about the work that we do in licensing, and the licensing report was born. And that still provides great information to the market about what's happening with our licensing work. We know it's become quite valuable to industry in terms of that transparency. I would actually point, because there's been some media coverage lately about over-the-counter and derivatives licenses, and some coverage in some media outlets about that. I'll just note that in our very first licensing report, in that report, we made a number of statements, direct statements, what is now a number of 4 or 5 years ago, about our view about the over-the-counter derivatives and FX type licenses. And this is not something new to us that's in the media just now. This is something we've covered for a while. So if anyone hasn't read that very first report, I would encourage you to do so, because I don't think our position about those licenses and the issues in relation to those licenses have changed. So if you get a chance, I would ask you to go and have a look if you haven't already. I would also end just in sort of my look at down memory lane and to say, as Diana said, this is the 5th meeting, and a number of people around the country have contacted us over the years and said, well, look, can we get this into a wider audience and use some of the tech that's now available? I am sorry to say it probably took a pandemic for us to get there, but we are here and we are glad for that. And we're glad that we are able to get so many people along to hear about what's going on in licensing. As Diana said, and I'm sure the team's quite fearful that I'm going to go over time, but I will cover a couple of things that I think are important on a wider scope that will impact yourselves, the organisations you represent and work for. The 3 things I'll try to quickly cover are ASIC industry funding, the ASIC registry, and our regulatory portal work. As you know, the ASIC industry funding regime took effect on 1 July 2017, and about 95% of ASIC's regulatory activities will be recovered in the form of an industry funding levy. The remaining 5% are recovered via regulatory fees for transactions initiated the rest of the applicant. For the 1920 year, ASIC expects to collect approximately $324 million in levies, but we are cognizant of the economic hardship facing business. And we do have relief options in place. For example, we can offer payment plans in exceptional circumstances. We can waive all or part of a levy, but relief is only available once the invoices have been issued. The due date for industry funding annual returns for 1920 was the 1st of October, and the actual regulatory costs for 1920, though, will be published shortly this month in December, and we will issue invoices for the 1920 levies in January next year, January 21. There is a preparation of the 2021 Cost Recovery Implementation Statement, the CRIS. That's underway, and it will go out for consultation, but it's expected to be published in March 21. That CRIS for consultation will include the outcome of ASIC's 3-yearly review on regulatory fees. Second item is about our the registry modernisation program, or modernisation of business registers, as is more formally known. That program, as announced by the government, will combine 31 ASIC registers and the Australian Business Register and provide the foundation for the delivery of a director identification number across companies in Australia, which is long overdue. And to be honest, has been a personal project and passion of mine to push for this to happen. So we're really pleased to see this is now getting off the ground. It is a 3 to 5 year program. It's led by the ATO. It was funded in October this year through the budget, with the enabling legislation being passed in June this year. Subject to finalisation of the budget allocation, ASIC's going to receive around about $28 million this year for program funding to start this work. The target date for the change in terms of responsibility under a machinery of government move will be, the target date is the 1st of April next year, where ASIC registry operations and staff will transfer to the ATO. At this time, our registry continues to meet all its public service charter commitments and to maintain all registry services, and that will continue. But the modernisation business registers package will effectively mean that over the next 3 to 4 years, there will be built a new modern platform rather than the clunky thing that's been there for 30 years. And the ATO are in the process of building that. And they are moving quickly. The Director ID platform is nearly finished. It's just a question of launching that in proximity to when the company's platform will be available. So you'll see more announcements as that go. I mean, the complete budget for the complete program is in fact nearly $420 million across the next 3 to 4 years. And the great thing about that is that will really support Australian business in a modern digital way, to help the real economy in Australia. That will provide better data, better search solutions, a whole range of other benefits to the business community. It'll obviously provide benefits to us as the regulator, because we'll have much better registry data that we can rely on then, in work with other agencies such as the ATO and Phoenix and other things. So a raft of those measures are actually very exciting, but it is also the end of an era. ASIC next year celebrates 30 years of history. And basically in that 30th year, we will see the core reason why ASIC came together being our registry business, then move over to the ATO to form what will become known as the Commonwealth Business Registry Service, or the CBRS. You'll see more information about that in due course. The last thing that I wanted to talk to you about was our regulatory platform, portal, and the transformation work we've done. Again, with a little look down memory lane, for those of you who attended the 2018 Licensing Liaison meeting, I mentioned that ASIC was in the process of making some substantial improvements to how it operates. That was about how you interact with us, how you apply for licenses and following. That also meant internally that ASIC upgraded its own internal platform and its our own technology processes. And we have come a long way in implementing that. That is effectively very close to finished across the organisation internally, and that's internally produced much better internal search platforms, but also the way that we measure and control our work and watch our workflows as work goes from the start to the finish within our business processes, from the time someone complains about something all the way through to enforcement activity. So our regulatory work is now recorded all in one place, and it makes it easier for us to trace those matters, helps us with our supervision work, our investigatory work, and our enforcement work. And it provides us with a much better digitised data platform to be a much more effective regulator in that space. But since my update in 2018, we also launched the ASIC Regulatory Portal, which is a more public, obviously a more public-facing impact of that change and that transformation program. It is a new front door into ASIC, and it also is a central access point for a growing suite of our digital services as a regulator. The portal isn't news to many of you here today. We know licensees are engaging with their annual industry funding obligations, as I mentioned before, and everything on that platform from a user perspective is done using transactions or smart forms to make life a lot easier. They're structured to make it easier for stakeholders to provide ASIC with the required information in an upfront fashion. We've got a range of security features in the portal to ensure stakeholders can determine who can see, edit, or submit their transactions. Stakeholders can also record correspondence with ASIC about submitted transactions and track their status. And there's much more pre-filling happening now using information you've previously supplied, along with the ability to easily attach documents. Back in 2018, I did emphasise regulatory services will be available via the portal in stages, and we were hopeful to have the Australian Financial Services Licence and Australian Credit Licence on board by mid-2019. And that would include the full licence application processes, but also maintaining various licence conditions, but also variations. Fortunately, we're not quite there yet. The timeline for delivery was initially aligned to what some of you will know was meant to be a public tender process for ASIC's registry operations. As you know, and as a matter of public record, that didn't proceed by decision of the government. And as I mentioned before, we've now moved to the registry operations being transferred to the ATO as part of a bigger singular Commonwealth Business Registry service. As a result, this program's had a couple of impacts in the timing for licensing. So now we've had to significantly adjust from that old alignment to a new alignment now with the new registry platform, because what we want is when you apply for a license, be it a credit license or a financial services license, or vary those, that effectively it's working hand in glove with information already contained in that Commonwealth Business Registry service. So that helps us with pre-filling and those things. So that's going to delay impact, the delivery of financial services licensing, Australian credit licensing applications going through our new portal. But the work on that has truly begun. In fact, we're well advanced. But as I said, now we have to align that back through this new program and the 3 to 4 year program that's happening at the ATO. A key point here is that you're using the portal already, which most of you will from industry funding metrics perspective. You will be familiar with the look and feel and functionality. So anything new that's coming down the pipeline will look and feel the same. I'll have a little bit more about the dates in a sec. A quick summary though of what's on the portal already. Industry funding's there, as I said, and as I said, the next round of invoices will come out in January. Self-managed super fund auditors went live on that portal and platform in March last year. So applications to be registered as an approved self-managed super fund auditor commenced in the portal, along with submitting annual statements and being able to update various details. That was in fact our very first and small pilot for our new approach to licensing. So we put that in first as a way to test what happened with a much smaller regulated population. In August last year, the portal became a new channel through which ASIC can now serve official notices and receive notice responses. And again, some of you may have had some experience with receiving notices through that portal. Breach reporting in March this year. In fact, we got breach reporting up on the new portal just before a lot of our staff left the offices to work from home due to COVID-19. So in March, AFS licenses and registered company auditors commenced using the portal to submit breach reports, and that replaced the existing submission channels, mostly through email. The new online forms for submitting a breach report feature mandatory fields designed to help licensees comply with their breach reporting obligations. It also allows a record to be there for previous breach reports and the ability to track the status of submitted breach reports and the ability to correspond with ASIC Online about those breach reports. In July this year, the portal also replaced other channels as the primary way to submit applications for relief and lodging fundraising and corporate finance documents with ASIC. And primarily these transactions were being lodged by law firms, but we also wanted to see that on the platform. So you can see that we're trying to push all of that regulatory business into that ASIC portal. So in wrap up, I would say that, and just again say that given the current timing of the transfer of the registry operations to the ATO, we do expect to have now the AFSL and credit licensing applications and variations in the portal sometime in 2023. That sounds a long way away, but it'll be very close. Again, the alignment of that is with the company's portal on that new platform at the ATO. We just didn't want to release it and then have to do major rework afterwards once that portal at the ATO goes live. So we're trying to align those two things together, and that will ensure good and easy integration between transactions relating to the corporate body, but also as a licensee, registrant and representative thereof. So that's where we are with transitioning more of our services online. The portal has stood up to tests with thousands of transactions now being submitted, and we're very happy with how that's being adopted and utilised by our stakeholders. And as a result of that, that just shows our commitment again to being a much more digitally accessible business at ASIC. I'll stop there. I don't think we'll take questions at the moment. I think you're holding them till later. Is that right, Nicholas? Yep, very good. On that note, then I'll hand back to the team. Thanks, everybody.
Thanks very much, Warren. I think I'm up next. So hi, everyone. I'll be just taking you through some of the high-level licensing statistics and highlighting a few of our key performance metrics. So some of you will be familiar with some of these slides from previous Liaison meetings, but I'll be covering the overall volumes over the last 3 years as a trend, looking at specific details, focusing on the 3 categories of AFS licenses, credit licenses, auditor activities. And then I'll have a look at the overall service charter and how we've performed against that, as well as a breakdown of how we've got to reaching our 90% KEI within the 240 days. I'll also talk about an indication of volumes across various business models, and then look at a sample of those and look at the breakdown of how we progress to get to the completion rates on those. So if we go to the next slide. So this is our 3-year applications received, and the darkest line is the last financial years, and then the blue one is the previous year, and the grey prior to that. So you'll see from this graph that volume of applications that we're receiving is down from previous years, except there's been a slight bump in January and February of this year compared to previous years, but otherwise the volumes are slightly down. If you go to the next slide, we'll see that on hand, our volumes, obviously we're doing better than we've done in the past with the number we have on hand. In the last 6 months, that's coming closer to what we were achieving in the previous financial year. On to the next slide. Okay, so this is just a snapshot of the last financial year, breaking down into the 3 categories. You'll see that obviously the largest portion of our work is in relation to the financial services area, and then credits comes next with a very much smaller percentage of auditor related applications. Next slide, thanks. So this is the financial year trend for AFS licenses. So you'll see from this that the work on hand is the grey bar, and the dark blue bar is the matters that we're able to complete for that particular month. And 8 of those, you can't see it, but 8 of those 12-month period, we've completed more matters than we've received. So in that sense, we're able to get our volumes down incrementally as a result of that work in the space. I'll talk more about the KEIs later, but the dotted trend line across the top there shows how we've performed in those months against our KEIs, with mostly achieving the 70% mark, but a few times dipping over and occasionally going quite a bit over. Next slide is just the same corresponding information in relation to credit. And we, again, correspondingly, there's 8 months there where we've completed more matters than we've received. And our KEIs are very strong in the credit space as well. So company auditors, so the next 2 slides are company auditors than SMSFs. And as I mentioned earlier, there's a lot fewer applications that we receive in this area, with again, the completion rates being higher for most of those months across both SMSF and company auditors. Our performance results for company auditors is higher than what we're seeing in the SMSF space, but we do get slightly more SMSF applications than company auditor applications, which is the next slide. Okay, and then we'll move on to the next slide, which is the overall performance within the licensing area. So our service charter is to achieve 70% of applications that we receive within 150 days. And you'll see from that on the right-hand column that our results are above, for the 150 days, are all above the 70% mark. And compared to the previous financial year, it's higher than all the other, in all categories, except for the metric of varying a AFS license, where there's been a lower level, but still above the 70% rate. Okay, so this graph just maps out how many applications we're able to complete within, 25% completed, 50% completed, 70% and 90%. And you'll see from that, and the dark line represents the last financial year and the dotted line the previous financial year. It's pretty similar metrics in terms of what we're achieving, except for a slight increase of 10 days, 9 or 10 days, I think, to achieve the 90%. And we're putting that down to things like the COVID experience and the reforms that have resulted in more information being required to be obtained prior to being able to finalise those applications. The credit, it's again pretty similar scenario, similar numbers to get to 25, 50 and 70. The highlight here is really that we've managed to get the 90% completion rate down to 151. Okay, this graph just summarises some of the more typical business model application types that we receive. And you'll see that the financial advisor space is by far the largest individual area of business activity, followed by the wholesale scheme operators. And you'll see that from this graph that the lighter blue represents the last financial year, and the darker blue the previous financial year. And corresponding with the earlier slide, you'll see that volumes in most categories is down compared to the previous financial year. The only two, and it's not that many, but the only two that have shown a bit of a increase have been the market participants under the securities dealers category, and remittance and non-cash payment providers, which is just slightly high as well. Okay, so now just turning quickly to the AFS space, in terms of, we've just picked out a couple of the more typical business models, being advisors, the intermediaries in the insurance space, MDA providers, and the non-cash payment people, as well as margin lenders. And you'll see there from the volumes that, again, financial advisors is obviously, personal advisors are the highest category, similar to the previous financial year. And the other, you can see what they are there, with the other ones being the authorisation for being the most complex, and that's down from previous year. Now this slide's a bit busy, but what it's trying to represent is the darkest bar represents the number of matters that we are able to complete within 90 days, the lighter blue bar between 90 and 150, and the greenish bar over 150 days. And just the takeaway from that slide is really to say that on average, the financial advisor's authorisation takes the least amount of time to complete, and we achieve about 83% completion rate within the 150 days, and correspondingly for the most complex type of business model, which is the fourth authorisation comprising the market makers and the responsible entity types and custodians. That one has a completion rate of about 33% within the 150 days. So just in closing, the last point is really the proportion of applications that are approved over 150 days has reduced compared to the previous financial year, and that in all categories except for the margin lending and non-cash payments, which is slightly gone up a little bit. I think that's my last slide. Thanks, Deanna. Nicholas. I think I'll now hand over to Nicholas.
Thank you, Ping. Hi, everybody. My name's Nick Vonax, one of the senior managers of licensing. Today, I'm just going to go through some of the legislative and regulatory reforms that have occurred and are upcoming. And my colleague Gerard will conclude this session. So firstly, I just want to go over the stronger regulator reforms, which were legislative reforms that passed on the 18th of February 2020. The Stronger Regulators Act, amongst other things, aligned the probity tests that were applied by ASIC when determining whether to grant a new or varied AFS or credit licence. We're now required to have regard to the fit and proper person test for AFS licence applications rather than the good fame and character test, and to apply the fit and proper person test to a wider range of people for both AFS and credit licence applications. So this test now applies to all officers, partners, trustees and senior managers of an applicant. It's no longer restricted to those responsible for day-to-day operation of a business. Any controller of the applicant, as well as any officer, partner, trustee or senior manager of a controller of an applicant. The reforms require ASIC to consider all applicants against the fit and proper person test and to necessitate the provision of additional information. As Deanna mentioned earlier, our approach to fit and proper people is outlined in Info 240 and 244 for credit. In summary, we currently require an applicant to list all fit and proper people, or all people who must be considered under the test, provide a statement of personal information signed by each of these people, provide a criminal history and bankruptcy check for each of these people. As Deanna mentioned, we are aware through feedback from applicants and service providers in relation to the difficulty that some applicants have obtaining checks and the undue burden that those obtaining those checks may have on particularly officers of overseas controllers, where those officers might be subject to a fit and proper person test in a different regime. So, for example, United States SEC requirements. We have considered that burden, and we intend to shortly update our information sheets to reflect that ASIC will accept alternative evidence to establish that these people, that is officers, partners, trustees and senior managers of a overseas controller, are subject to a fit and proper person test in a different regime. More details of what that evidence looks like will be provided in the information sheet, but the important thing I would flag is we still are obliged, ASIC is still obliged to apply the fit and proper person test and make sure that we consider each of the matters that we are required to consider under the legislation. So the evidence we would expect to see from an applicant would still allow ASIC to make a determination that it has no concerns that this person is not fit and proper. I'll just go through the other amendments to that to the Corporations Act. So the Corporations Act was also amended to provide ASIC with an express power to request information from an applicant in relation to an application, an audit report, or fit and proper person information. This power already applied to credit license applications, and essentially means if an applicant does not provide the requested information within the time frame specified, and no extension request has been made and approved by ASIC, the applicant is deemed to withdraw the application. We highlight this as important so that people are aware that they need to provide the requested information in full and within the requested timeframe. And then if applicant is unable to provide the information, they should get in touch with the relevant analyst as soon as possible. Otherwise, they risk their application being taken to be withdrawn. The stronger regulators amendments also created a new power for ASIC to cancel an AFS or credit license in the event the licensee has not commenced operating a financial services business or engaged in credit activities within 6 months of the license being granted. Licensees are required to notify ASIC of a failure to commence within 6 months. To clarify, because we have had some queries, ASIC does not expect licensees who have commenced providing some, but not all, products and services authorised under its licence to provide a notification. We have received a number of notifications as the transition period for the notices commenced on approximately mid-August. And we are currently advising licensees that in light of the impact of COVID-19 pandemic, our intention is to not cancel a license unless we identify specific concerns about warehousing or the commodification of a license. Further information in relation to how we approach this is available in the licensing annual report that Deanna mentioned earlier. Just briefly, other changes made by the Act were to provide that we, ASIC, must refuse a license application where we have been provided false or misleading information, or there is an omission of a material matter in an application, report, or statement from an applicant. The requirement for a licensee to notify ASIC of a change in control has been amended. Licensees are now required to notify ASIC within 30 business days of when an entity starts to control or stops controlling a licensee. The penalties for making false and misleading statements in documents, so that is provided to ASIC, that is including in a license application, have now been aligned. And we've also amended the procedures for variations. So there is now a right for a hearing before an application for a variation to an AFS or credit license is refused. So the regulatory guidance, particularly regulatory guides 1 to 3, but other guides as well, have been updated, and our internal processes now reflect these changes. I'll just briefly go over the new types of licensed entities that ASIC has been responsible for considering in the last year. So foreign financial services providers. So on the 1st of April 2020, a new regime started for foreign financial service providers. And as a result, these providers can now obtain a AFS license to provide financial services in Australia to wholesale clients, which is subject to a streamlined licensing assessment. To be eligible for this assessment, the foreign provider must be authorised under an overseas regulatory regime that ASIC has assessed as sufficiently equivalent to the Australian regulatory regime. Foreign financial service providers who apply for the licence are exempt from certain obligations that apply to other AFS licensees, such as financial and organisational competence requirements, which enables a streamlined assessment of those applications. We would just highlight that providers currently relying on the pre-existing relief will have a 2-year transition period until the 31st of March 2022 to make arrangements to continue their operations in Australia. To date, we've only received a relatively small number of applications, notwithstanding that we are almost 8 years into that 2-year transition. So we really would encourage any prospective applicant and service providers to lodge their application as early as possible, given lodging applications closer to the last minute would increase the risk that a licence not be awarded by the end of the transition period. Information in relation to FFSPs and how they can apply, and the arrangements for those FFSPs is available in Regulatory Guide 176, as well as the licensing kit for AFSL Regulatory Guides 1 to 3. Funeral expenses. So the Corporations Act was the Corporations Act was amended to remove a previous exemption that applied to providers of funeral expense facilities to hold an AFS license. So a funeral expenses facility is a scheme or arrangement for the payment of money when a person dies for the purpose of paying all or part of the expenses or incidental to the person's funeral, burial, or cremation. So as a result of the reforms from the 1st of April this year, providers of a funeral expenses facility need to hold an AFS license and comply with relevant obligations unless the facility doesn't meet the definition of financial product. There's a new info sheet, Info 243, to provide further information on how those new licensing requirements applies. Litigation funding. So many of you would be aware of the government's announcement on the 22nd of May 2020 that it would regulate litigation funders under the Corporations Act. As a result of amendments to the corporation regulations from the 22nd of August, operators of litigation funding schemes have been generally required to hold an AFS license, and litigation funding schemes need to be registered. ASIC announced the provision of some relief from requirements that would typically apply to these entities, and has worked with industry to ensure a smooth transition to the new regime. Information about the relief and the transition is available on our website at that link, which will be available. And just flagged on this slide as well how many licenses have been issued in each of those categories. In terms of upcoming reforms, there is a lot going on in this space in 2021 for licensing. These upcoming reforms will require new categories of persons to hold either an AFSL, a credit license, or a professional registration. I will go through these rather briefly, but there's a lot more information available on the links provided. So in relation to super trustees, subject to legislative amendment, all superannuation trustees will be required to hold an AFSL to operate a superannuation fund. The changes form part of the government's response to the recommendations in the Royal Commission final report, and are designed to enable ASIC to play a more effective role in regulating the superannuation industry. For those trustees that already hold an AFS licence, the bill provides that a new licence authorisation, which is to provide a superannuation trustee service, will automatically be deemed to apply. So no steps will be required by these trustees to acquire the authorisation. For non-public offer trustees that do not hold an existing AFS licence or hold an AFS licence to provide advice only, there will be a streamlined application process for the trustee to obtain an AFS. We will be writing to those affected trustees to provide information on how to get the licence and the authorisations they need. In relation to small business restructuring practitioners, so from the 1st of January 2021, subject to amending regulations, a new category of restricted liquidator, known as a small business restructuring practitioner, will be created. So small business restructuring practitioners are registered company liquidators, restricted form of liquidators, and ASIC's responsible for, well, the licensing team is responsible for receiving those applications and supporting a committee who is responsible for making determinations on registration of liquidators. Just briefly on responsible lending obligation changes. On the 25th of September 2020, the government announced proposed reforms to the responsible lending obligations that are contained in Chapter 3 of the National Consumer Credit Protection Act. The proposed reforms will amend the obligations that apply before entry into a credit product or provision of credit assistance. So ASIC's guidance relating to the current responsible lending obligations will be reviewed and updated when the proposed reforms are finalised. With that, I'll throw to Jared Method.
Thanks, Nick. Excuse me. Good afternoon, everyone. Gerard Mithen, Senior Manager within the licensing team. Just in terms of other licensing related reforms, from the 1st of April 2021, subject to amending regulations, debt management firms will be required to hold a credit licence and meet the ongoing obligations that apply to credit licensees, including holding AFCA membership. From the 1st of January 2022, subject to legislative amendment, insurance claims handling and settling services will be required to hold an AFSL. To assist industry to comply with the timeframes in the bill, ASIC has released an information sheet in draft form now, as well as a draft version of the licensing proof documentation, which will be required as part of any application. This approach should hopefully help give industry participants as much time as possible to consider whether they need to obtain or vary an AFS licence, and if so, what they'll need to do. ASIC will issue the final information sheet and proof document ahead of the commencement of the reforms, and ASIC expects to start receiving licence applications from the 1st of January 2021, subject of course to the bill's passage before the end of this year. And moving on to the next slide and some other items of interest. As you are aware, in many instances, ASIC requires persons seeking a licence to obtain professional indemnity insurance coverage or have alternative arrangements approved before a licence is issued. ASIC Licensing is aware of concerns from some applicants regarding the cost and availability of PI insurance. However, most applicants are still ultimately able to obtain cover. We will continue to monitor the availability of PI insurance and impacts it may have on the licensing process. If you have any information you would like to share with us in relation to PI insurance availability or cost, please feel free to get in touch with any one of us. On the 1st of September 2020, the Australian Government introduced a new Enhanced Regulatory Sandbox, or ERS. The sandbox provides an environment for people to test certain innovative financial services and credit activities without first obtaining an AFS or credit licence. The sandbox, or current sandbox, supersedes the previous regulatory sandbox administered by ASIC and allows testing of a broader range of financial services and credit activities for a longer duration, up to 24 months. A person intending to use the ERS must complete and lodge with ASIC a prescribed form for the financial service or credit activity that they plan to test. The licensing team will review the notification and advise the person within 30 days whether ASIC will exercise its power to exclude the person from the use of the ERS. ASIC has published Information Sheet 248 to provide further information to prospective participants. We publish a public register of businesses who are using the exemption, and to date, one person has commenced operation dealing in non-cash payment facilities to help customers set up their own payment plan and make flexible payments towards bills such as council rates. While not mentioned on the slides, in terms of other items of interest, I would also like to briefly make mention of two licensing-related media releases issued yesterday by ASIC. One of these releases related to the AAT upholding a licensing refusal decision involving a lack of disclosure and the provision of misleading information to ASIC. The other related to a conviction for knowingly making a false statement in documents lodged with ASIC, including a licence application. Both releases, amongst other items, reinforce the need for applicants to deal openly and honestly and provide full and frank disclosure to ASIC when applying for a licence and when responding to our requests for additional information. I would encourage you to take a look. I'll now hand over to Deanna and Peng for the Q&A session.
Hi, Deanna, I know you were having difficulty earlier. Can you?
Yes, thanks, Peng.
Okay. All right, well, thank you everyone for your time, and we've received a number of questions. So we'll just go through those. Deanna, do you want to kick off, or are you happy for me to?
Yes, happy for you to go ahead. Thanks, Peng.
Okay, sure. We've got one question that's directed more to our finance department, so we'll respond to that separately. The next question relates to a query about the foreign AFS holders and the need to nominate responsible managers, and the idea that there's no assessment of competency, and the concept of responsible managers seems to be a bit foreign to some foreign licensees. So why are we asking for fit and proper checks in relation to these people? The answer to that is that the responsible manager regime is obviously a creature of ASIC, and it's to do with who is running the financial services operations in relation to the license. So we do need someone. A controller is someone who can be, once removed from the actual operations of the business. So I think that's where the discrepancy between just having the review of the controllers as opposed to the persons who are responsible managers. And I just note that the definition of officer includes senior managers, which is a concept that is used in many other jurisdictions, including the many that we are prepared to accept equivalency from. So if there's a particular issue with someone saying that their controller meets the definition of responsible manager, then I'd suggest that they could just be the people that are put forward in name as being the responsible managers. But if you have particular difficulties, then obviously please reach out to the analysts that are asking you the question, or putting it forward in your submissions when you apply. The next one just relates to foreign, the status of fit and proper. And I think, Nicholas, you've already covered off on that question of giving some latitude there where it's appropriate to deal with foreign fit and proper requirements. And then the last part of that question just related to the A5 proof in terms of streamlining and limiting the number of proofs. So there are the B proofs which relate to persons, which are not required to be provided. And the business activity description is something that the actual regulations in the Act require us to obtain. So under, I think it's 913A, the information that has to be provided has to be in relation to the business activities. So I think there's no getting around having to provide that information in that proof. So I hope that answers that question. If you want to follow up, please feel free to contact me. The next one just is in relation to, I forgot to mention. So the first one was from Mark McFarlane of King and Wood Mallisons, and this one's from Ronald Chan of APAC. And Ronald's question just relates to questioning the need for having regard to the practical influence aspects of control under section 910B, as well as what we've stated in our report about the stronger regulations in report 671. And the question relates to why practical influence is not considered in light of the definition of control. I think the answer is, if I understand the question correctly, is that it is considered. It's just that practical influence is one aspect we expect applicants to disclose them as controllers. If they do have the practical influence, it's just that it's not limited to practical influence. So where you've got legal control as a result of being an officer, for example, of a parent entity, then you by definition be a controller, even though you may not actually have practical control of the subsidiary. The next question, I think that's one for
Thanks, Pete.
Nicholas.
I can take this next one. So that last question was just raised by Ronald Chan by APAC, at APAC. This next question just relates to what license applications trigger Info 240. So I think this question from Denise at GRC Essentials is querying if there's some small variations to a license application, whether the fit and proper person test applies, and it does. So Info 240 outlines our approach to obtaining sufficient information to apply the fit and proper person test, which is a legislative obligation that ASIC must apply. So the Corporations Act and the Credit Act require ASIC to apply the fit and proper person test for variations, and doesn't make a distinction based on the size or scope of the variation. So in that since Info 240 is going to always be relevant to each variation, and Info 244 for credit applications. I will note if the licensee has recently submitted a variation, then it is possible that those people proofs might be accepted for the subsequent variation, but that would be the limited circumstance which we wouldn't need to obtain new fit and proper people proofs. Thank you. Okay.
Sorry, I was just reading the next question. So what are we up to now? Sorry.
Question 5 from Lucy Dickens at PwC.
Okay. All right. So we'll send round it was the first licensing report that was prepared. I can't remember the number of it, but we'll. If you go to the landing page, which will circulate, it's got the list of all of our reports and also the liaison meeting slides. So you'll find that being the first report that we prepared on that page.
So that question was just if we could provide the information on the previous reports where OTCs are mentioned.
Yep, sorry. The next question relates to the new registry and functionality to search the AFSL register by license authorisation type. So it's obviously being built at the moment. So that would obviously be a very useful functionality. And I think you can actually do some searches. The information that ASIC provides to data.gov does provide some visibility over the types of authorisations that are held. So that information is already somewhat available, but yeah, certainly the greater visibility is something that we're trying to achieve. So so we'll definitely take that on board and look at that. The next one is how have the new breach reporting portal impacted your response and processing time for auditors and license breach reports? Is that something, Diana, that you have?
Oh, thank you. Sorry, I've just been having some technical difficulties and I keep clicking off video, so my apologies. In terms of response time, look, at the moment we've got about 300 breach reports on hand, which is pretty good. We were on top of it a couple of months ago, and it has impacted in terms of increase. But we're certainly keeping, we're getting on top of it. Over the last probably 3 or 4 weeks now, our numbers were looking pretty good a couple of months ago, but it certainly has impacted slightly. I don't have the numbers in front of me, but we have seen a bit of an impact across the board on those. Lucy's also just sent through an extra question while we're on Lucy. So Lucy's asking, we've mentioned that no licenses have been issued in relation to funeral expense providers, and does that include variations to existing licenses to include this authorisation? I think the answer is yes, Peng.
Yes, no licenses have been issued to date, including no variations. I think we might have lost Diana again. Okay, I'll handle the next question. Just relates to why an AFS license. This is from Steve O'Connell from SOCCAL. Why are AFS licenses not automatically amended by ASIC in the event that a named registered MIS is deregistered? I think the answer to that is that that is a licensee initiated action to decide to, for whatever reason, to deregister an MIS, and so it's because it's a voluntary activity that, for whatever reason, that a licensee's undertaken. The regime provides that if a licensee is undertaking anything on a voluntary basis, that's a licensee initiated action, and therefore the consequence of that is, for a license application, is that it's also something that is required for the licensee to initiate. If ASIC were to do it, then it'd have to do initiated as an ASIC initiated, and then we'd have to give rights of hearing and rights of appeal, and we don't really know the circumstances for why it's deregistered, so it's really up to the applicant to make that submission. Okay.
The next question is from Penny from Allens. I'll just read it out. In relation to info sheet 251, could ASIC let us know if there are any specific concerns regarding industry practices that led to us issuing info 251? For example, we have not come across the structure described in example 3, which is a trustee relying on both the intermediary authorisation exemption and the authorised rep exemption in relation to the same activity.
Yeah, okay. Oh, I can probably take that one, Deanna. So in relation to the first part, yes, I believe that that ASIC has seen examples where people are attempting to rely on both of these exemptions together. So that's hence the reason why we have issued this information sheet. The difficulty that ASIC has is obviously that in relation to the use of the intermediary authorisation exemption, there's no notification requirement of ASIC. So someone seeking to rely on it as a licensee being the intermediary or the issuer being the unlicensed issuer can come to that private arrangement without obviously having to notify ASIC that anything's going on there. So, but we have seen some instances where people are purporting to use those together. In relation to the second part of your question, I think the answer is no. That the info sheet is specifically directed at attempts to try and use these two exemptions together rather than in respect of using appointment of an authorised rep for any other capacity other than for the issue exemption under the intermediary authorisation.
Thanks,
I hope
Ping.
that answers your question, Penny.
Thank you, Ping. It looks like we've covered all the questions we've had. I hope we haven't missed anybody. Certainly open to just waiting to see if there are any more coming through. And Nick or Jared, if you can just let us know if anything comes through. And certainly, please invite you to send emails if you have any other questions following the presentation that you'd like us to address. We're certainly happy to consider those outside of the presentation.
Sorry, Ping.
You go, Nick.
I was just going to say, we've had a minor IT issue, but we are aware there's a question coming through. I'm not sure who it's from yet, but asking when Info 240 will be updated. So I think that is referring to the changes to what evidence we'll accept for overseas controllers. We will update it as soon as possible, but I will flag that for any existing applications, we will accept that alternative evidence even if the info sheets aren't updated yet. So if there's currently an application you yet to make or one that's currently under assessment, we can adopt an alternative approach before the info sheets are updated.
Thanks, Nicholas. Just before I hand back to Deanna to close, just wanted to mention one more thing, and it's a theme that we've kind of emphasised at most of the liaison meetings previously, and that is that we would welcome any feedback that you have about the content and whether there are any other categories of information or issues that you would like us to present on or discuss. And similarly with our licensing report, you'll see that if you've had a chance to have a look at it, that it's we've made some significant structural changes to the document and hopefully made it shorter and more digestible and also more useful. So if you'd like to provide any feedback in relation to the content of the licensing report or what else you'd like to hear us report on that's relevant to licensing, please send us an email or give us a call. Thanks. I'll hand back to you, Deanna.
Thank you, Ping. Just to thank you all very much for bearing with us in this electronic virtual format today. We still have almost 200 of you online, so I do appreciate you hanging on and asking the questions. We really like to have your engagement, and we do welcome your feedback, as Peng has suggested. So with that, we've had no more questions through. I do hope we've covered the issues that you've raised today. Thank you again for joining us, and we hope to see you again for the Licensing Forum 2021. Thank you, everybody. Goodbye.